Well, that didn't quite work the way I wanted it to. Let's see here. Let's try to do this a different way. How about that? That didn't do it either. Gosh darn it. Okay, I may have to get rid of presenter view. Hello, everybody, and welcome. At this point, pay no attention to that man behind the curtain. I'm trying to get the right PowerPoint to work here, so we're going to go back to from the beginning, and oh, this works great. You can see the PowerPoint up there, can't you? So that's good. Let me see, did that work? No, that did not work. Okay, so we're going to go to another screen. I got here a couple minutes early just in the event that I'd have to fix some of these things. So that's what we're doing. We're fixing things. Screen number 2. So we go to that one and then go to that one and then go to that one. That doesn't do anything for you. Hey, Betty, how are you? Good to have you here. Thank you for being here. I'm going to have to bail on the presenter view part of this and just go right back to doing the slideshow from the beginning because the other way is not working. All right. So Betty, if you have a comment, let's see, resume slideshow. If you've got a comment, would you mind terribly putting it? Okay, there we go. I got that fixed. Okay, so could you put it into the chat? If I turn on the microphone for everybody, then or for anybody, then what happens is it unmutes you at the worst possible time. So thank you all for being here today, and we have quite a few celebrities, including Betty today. I'm pretty excited about that. Thank you, Betty. Thanks for being here. My name is Kevin Burke, and I am here at the Greater San Diego Association of Realtors, doing a first-class webinar. As you know, there is my telephone number. I would rather speak with you in person, so please feel free to give me a call. I even had an agent the other day call me up, and then I just missed it. And then she called back, fortunately, an hour and a half later, and because I would have, just keep calling. You're not bothering me. It's important that I get your call. So there's also an email address that works pretty well. And so obviously you can send me an email if it's something that I can handle at 2 in the morning when I am definitely up. But I want to be able to take care of, what it is that you've got going on. So that being said, let's see, is it going to let me go to the next slide? Never a dull moment around here. Resume slideshow, and then let's see. Okay, good. Okay, so I put some credentials up there, I guess, that make me qualified to speak about the subject matter today. As you can see, I have a broker's license in several states. I find that California was the most difficult. I think it just gets easier wherever else you go. I've been in real estate since 1979. I think, Betty, you and I started about the same time. A long time in real estate, right? So American Jurisprudence Award, graduated first in my class in law school in real estate transactions. So that was my specialty at that point. I do continue to teach continuing education for attorneys. I teach that at UCSD, and frankly, I've been teaching it for about 25 years. They told me when I first started teaching it that they were just looking for somebody else more qualified. You need to go to presentation mode, follow on the toolbar. Betty, is that still true, or can you see it now? Is it okay? Can you see it now? Please let me know. But they said at UCSD, they said they were going to try to find somebody, more suitable replacement, but that was about 25 years ago. So I guess I'm kind of getting away with it. I did teach at the college level for quite a few years. In fact, frankly, about 15 years simultaneously, sometimes with 3 different colleges. But what I found was that I'd really rather work with people that were in the industry and wanted to do better in the industry, rather than having 2/3 of the class just be there to get three units of college credits. So that's kind of why I made the switch. I don't know why I highlighted property management, other than the fact that I do that at I use this presentation for that as well. So let me see now if I can get this to go. Betty, help me out here. Okay, so I have totally botched this up. You need to go back to preview, and at the bottom is a bar to go to presentation mode. Your slide is cut off. I think I see what you're saying. I hate to have to start over again. So let's hit on this and resume slideshow. See, that's what I get for trying new things. Sometimes it just, sometimes you're best just staying where you are, right? And that's what this is all about. So I have two different screens going on, and unfortunately hit exit. Betty, you're a lifesaver. Does that do it? Let's see here. Not quite. Exit. I may just have to get out of the presentation and start over again, right? Okay, so let's go to close, which will mess everybody up. Okay, there we go. And then let's see if I can get it back. So here we are down at the bottom. Okay, share screen. I'm running it on another screen and I just can't see the screen. I mean, that's a real challenge for me. So let me see here. Where's my screen? And I should pull up the PowerPoint. Where is it? Linda, help me out here. So open and all about disclosures. And folks, I promise you this will be worth it when I finally get this fixed. So, okay, so I see it fine on my screen now, and that means that I'm not sharing. So I've got to go to the share screen. There it is. And then we hit share screen, and then I hit that one there, and that should do it. There we go. Much better than we were before. Thank you, Betty. I appreciate your guidance on that. That's what we get when we have veteran instructors here helping everybody do their thing. So thank you again. I think we did it. Okay, worth the wait. Oh, thank you. That's very kind. Worth the wait. That's very kind. Thank you, Betty. So anyway, so on the left-hand side, all the stuff, and I was talking to somebody the other day. Oh, I know, a buddy of mine who's a Navy SEAL, and I said to him, I said, awards are for things you've done in the past. Tell me what you're doing today. And he really liked that statement. So I was chair of Risk Management Issues Committee West, and that was last year at NAR. Last year, I was also chair of Realtor Risk Management and Consumer Protection at the state level, as well as being on the Defense Strategy Committee. Next year, I will be the chair of the Legal Affairs Forum, and also the Betty, you're on this committee, I think, pretty sure, or forum, the Expert Witness Forum next year as well. So those are some credentials, I guess, that make me credible. We're going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I want to make that really clear. I have no interest at all. I think, frankly, they work harder than we do, and most of my time is spent chasing them around trying to get them to pay my bill. So anyway, I do a lot of trial work as an expert witness. And so, again, you may not call yourself an expert. DRE has said, don't call yourself an expert. You can do that if it's in a title, so like a certified distressed property expert, or in this case, a court certified expert witness. So I do a lot of trial work that way. Standard of care is my specialty. Agents' duties of inspection and disclosure. Oh, we might be talking a little bit about that today, right? I think so. Okay. And then finally, market conditions in San Diego. And hopefully you're having as good a market as I am. It's just really interesting to me how market is really just a presence of mind. And so, it's always work, right? I mean, it's always going to be work, but hopefully you're enjoying it. Linda asked me the other day, she said, have you thought about retirement? And I after I got off the floor from laughter, I was like, retire from what? I really feel like I'm retired now, right? I get to do what I really love to do, which is frankly a decision I made after law school is that, I just really love real estate. I was, at that point, I didn't realize I was halfway through my real estate career. That was back in the mid 90s when I got my law degree. So it was all good. So do what you like to do, folks. And hopefully if you're having half as much fun as I am, then I'm having twice as much fun as you are, and hopefully that'll get a chuckle out of some of you there. So conversation today not intended to be a substitute for the advice of your broker, nor for that of your attorney. please consult with them as appropriate. Okay, so talk today is intended to be interactive. So please, and thank you. Betty's already been testing out the Q&A thing. It's working really well. Please ask questions or offer input by utilizing the Q&A button. Okay, I've turned chat off, so that does not work. I look forward to hearing from you. I really do. You would help me shape the direction that we're going to go. And so here we are today. We're going to talk about disclosures. And I do want to hear about, what experiences that you were having. I know that I'm a practitioner like you are. I have a lot of interaction with people that in real estate transactions, we do a lot of transaction management in our company here. And so some of the things that I'm seeing, I will talk about, but I need to hear what you're seeing as well. And so we'll take care of that. And so we do have our crowd is growing today. Thank you all for being here. I very much appreciate your time. Okay, so this afternoon, we're going to talk about, gosh, it's got to be four of my favorite forms, right? So the TDS, the SPQ, the SPQA, and the AVID, and why are they relevant in a real estate transaction? And I'm going to hit you with some stuff that's going to really blow your mind, as well as giving you a list of court cases if you're interested in it, because my stuff, half of my world is in the legal, arena, and the other half of it's in the real estate arena. And listen, I just want to help, right? So, whatever I can do to help you, that's what I'm here for. So, but that we're going to go into those forms. We're going to kill it. You will know those forms probably better than anybody. And most of you know, I used to do a 2-hour class just on the TDS. But we're going to cover these pretty well. Coming up in the new year, I'm going to start doing more podcasts, more shorter versions of our classes. I got kind of, at the beginning of 2023, I got kind of stuck in the 2-hour mode, and I frankly think that's quite a bit. But I'm going to start doing shorter versions of things, and then guest speakers. I'm going to have guest speakers come in and talk. And Betty, maybe that's you. I don't know. I think that'll be a lot of fun. I've got a lot of follow-up on that. I know I've got the prosecutor for Huntington Beach wants to talk on our podcast about some experiences in a real estate transaction. And then, of course, I have a whole gaggle of attorneys that want to be involved in it. And so, I think it's a good thing, right? Because again, I want you to be safe. I want you to be okay. And so I want you to see what other people are seeing that are difficult for them. On Thursday, we're going to talk about the differences between a statutory and a contractual disclosure and what rights are associated with each one. And we'll talk about specifically, we'll break those down. We'll look at the purchase agreement. We'll look at where the disclosures are that are contractual. And then we also have the statutory disclosures, and we're going to hit that as well. And then in the afternoon, I don't know. This one always, people keep coming back to this. My award-winning Master My Farm, which, I love doing that one. Listen, if you're in real estate, you need to have a farm. And I'm not talking about fruits and vegetables and stuff. I'm talking about an area that you frequent, that you go to a lot, and that you want to do business in. And so I always said, do it where you live or where you want to live. For me, I live in Del Mar. I guess I could say, I could farm La Jolla, but I live in Del Mar. And so I'm probably going to farm Del Mar. Now, if I lived in La Mesa and I wanted to farm La Jolla, I will show you some tips and tricks on how to do that as well. So anyway, that should be a lot of fun. Okay. All right. That being said, and again, if you don't ask questions, I'm going to speed up. So that's just my nature. Thank you for joining us today. All about disclosures. I am here to wow you, hopefully in a positive way. So California is unique, okay? And so we're talking globally. We're talking at the 30,000 foot level. It isn't caveat emptor. And so most of us, I think, know what caveat emptor means. It means buyer beware. In fact, it's caveat vendor, which means seller beware. Okay. And so this switch changed. This all happened many years ago. Actually, back in 1963, the Lynch versus Savage case was one of the original cases that launched the fact that the seller needed to disclose things that the buyer clearly would not know. Most of us kind of hang on to the Easton case, and I'm going to show you Easton in a minute. because it's very important. But Lynch, it's LINGSCH, was the first case to kind of head us into this direction of where we are today. And so, listen, I always figure in real estate, we don't want to learn by trial and error. You make an error, you go to trial. I don't think that's the way to learn things. I think I'd rather learn it. Hi, Linda. I think I'd rather learn it essentially in classes like this. And I learn frequently from other people's mistakes. And so, I often say that it's not that I know more than anybody else. I've just lived longer than anybody else. And so that's kind of where we are right now. So let me see. Did I actually pull that part up? Let me see in my PDFs over here. Oh gosh, I have so much to show you today. I do have some summary charts to show you, the sales disclosure charts. And folks, as always, I will send all this to you. Send me an email. We used to just do it, just automatically send things out. But I found that we were sending things out to people that really didn't, want to get some of this stuff. But this is the sales disclosure chart. It breaks it down to where do you need it, and this again is available on the CAR website. But unfortunately, and I downloaded this morning at 9:30. But unfortunately, as you have probably experienced, as I have, it's finding this stuff that's the issue. And again, I will update this for you when we get up closer to December the 18th, which is when we're going to launch the new forms. So the new forms are coming out on December the 18th. For those of you who are keeping score, here is the summary chart of the sales disclosures. And again, if you go to the link, and it should have it down here at the bottom, the link to get in there, you can pull all this up, and these are clickable links. And then, as I said a second ago, on December the 18th, we're going to release the new forms. I have all of the new forms that are coming out. They're not done yet, so please don't use the draft versions of things. But if you are interested in that, my newsletter goes out once a week, and I have a link right on there that'll take you to all the new forms that CAR is revising. As a result of the Sitzer-Burnett decision, which came down a couple of weeks ago, they took all the forms off of the website because there were a couple of forms that they needed to work on. And I'm talking about CAR Legal, had some things that they needed to work on as a result of that decision. And so rather than putting them back up there and people thinking that it was the same thing as before, they just took them all down, worked on the forms, then they put them all back up again. So I have what I believe to be the last revision, and I don't mean to pick on Betty today, but I'm not sure, Betty, are you on that committee? I think you might be on Standard Forms Advisory Committee. So anyway, so that's going to be the releases that we're going to be doing. And of course, also subsequent to that, and at the beginning of the year, wherever, I'll be doing the new forms. And in fact, I'm doing new forms next Tuesday. I'll be doing that as a webinar on Tuesday. But then, coming right back up, here are the 2024 new laws. And so, this is really great stuff. I mean, some of this listings capped at 24 months, right? I mean, they got together with a DRE and they said, hey, listen, we don't think you should have a listing that goes for 5 years, right? That kind of thing. So anyway, lots of good stuff. NHD is going to be simplified quite a bit. So defensible space disclosures will change. So that's going to be good for all of us. And then what else? Here's the sales disclosure chart, in pretty form. Okay. All right. Question. Not this time. Oh, hi, Betty. Okay, I thought you were on standard forms. I think you've been on that before, though, right? I love standard forms. They won't let me on it, so probably because they figured it would take too long to finish anything that they were getting started. But I do help out with as best I can. So that being said, let's go back to the PowerPoint really quick. And why are disclosures required? And so people, you don't understand. If I'm going to get hauled into court, it's going to be because of a failure to disclose something. And so, try not to think about the form as much as thinking about what you're needing to do. And so why are those disclosures required? Well, they're required to protect the consumer. And so the intention is, of course, to protect the buyer. And remember, folks, it's the buyer who sues. So we want to protect ourselves, maybe even from our own client. Okay. And so in California, at least, it was interesting. I did a transaction. Again, I have a broker's license in Virginia as well. And so I figured if I get my broker's license wherever I had family, and then that way I could travel and everything would be, all my trips would be tax deductible. So anyway, I was doing a transaction in California, San Diego, where the buyer's agent, and again, I teach in Virginia. I'm a D4 certified instructor as well. But here I am in California, San Diego, where I live, and I had a transaction going on where the buyer's agent was from Virginia. Now, in Virginia, very, very different. In Virginia, it's completely the opposite. No disclosures, hardly anything at all. In fact, in some cases, and I'll show you this in a minute, the state actually prepares the disclosures for the seller. The agents are trained not to say anything. If you don't say anything, you can't get in trouble, which I think is completely wrong. But here's this gal from Virginia with a California real estate license as well, doing a real estate transaction with me of all people. And when we got started on that, and of course I send all these disclosures over in the beginning of the transaction, and she says, "My God, I've never seen so many disclosures." And I said, "Well, I know, but that's our law in California. We have rights to rescind contracts and things like that. And so, we're going to button it up. You're going to do the transaction, or aren't you? You know everything there is to know." Okay. So let's discuss some California appellate court cases. And again, I'm going to slow myself down a little bit. Thank you to Judy Preston, who is the chair of education this year, who called me up and said, "Slow down a little bit. You have so much to say, but we want to make sure that people are absorbing it and make sure that we're getting it." So I'm going to slow down just a little bit, but again, I will send all this to you, all of my research. But I've been loading the webinars up onto the YouTube website. So at the end of this, I'll have, if you've got a QR code reader for your phone or something, you can actually go to the website. I'll give you links and stuff like that to get there, and you can see all this stuff again and again. I'm really surprised at some of mine that are getting people back there. Actually more traffic than I'm getting on a live presentation. So for example, in this afternoon for the TDS, if you can't make that, I'll load that up onto the internet this evening as well. So there's some California appellate court cases that change the landscape for California real estate licensees. So let's talk about the Easton case. And so I'm going to go ahead and I'm going to pull up Easton, and Easton's one of my favorites. It created quite the stir. Let's go here. So this is the Easton v. Strausberger case. This case, actually, the lawsuit got filed in 78. Again, I've highlighted the important parts of it, but it got filed. Easton was the purchaser. Strausberger was the seller. I actually know some of the attorneys on this case. They come to our meetings. But this was a Court of Appeal of California case in 1984. And so the original case was filed in the 70s, late 70s, but it took that long to make its way through the lower court and then on up into the appellate court. And folks, I want to tell you, just as a precursor to all this, if you think the legal system is expensive, wait till you get to the appellate level. I mean, now you're really spending some coin on that. And I've got a case right now that is probably going to kick it up a few rungs. But anyway, bottom line is, here's what happened. We had the buyer purchases a property for $170,000 in May of 76. Okay, and escrow closed, and then the appellant in this case was the listing broker in the transaction. So there was massive earth movement shortly after they bought the home. And again, I'm going through this pretty quickly, and I've highlighted the salient parts. And when I send this to you, it will include the highlights. Portion of the property was fill, and there's a difference between cut and fill. In fact, it's a question on your TDS in paragraph number C2C, or section 2, paragraph number C, which is on page 2. So cause the foundation to settle, et cetera, et cetera. Cost to repair it, according to the experts, was around $213,000. Remember, they paid $170 for it, and now it's going to be another $50,000 or $43,000 large, as we say, to fix it. So unfortunately, the agents did some inspections. There was no requirement that they do those at that time, and they were aware of certain things that kind of tipped them off, like there was some mesh netting over part of the property, stuff like that. But they did not suggest to the buyer that they have soil stability or that kind of thing. And so, boom, here we got the slide, and there had been a slide prior to that, and I believe there's evidence that the agents weren't aware of that. The seller was aware, but the agents, all they saw was evidence that there had been a problem. So they didn't, yeah, here we go. The Strasburgers did not tell the agents about the slides or the corrective action that they had taken. So the buyer bought without knowing about it. Jury found everybody negligent. And again, here we are in a standard of care case. Okay, so let me see here, scroll down a little bit faster. Current law requires a broker to disclose to a buyer material facts known to the broker. Now, this is 1985 speaking here, okay, but unknown to and unobservable by the buyer. And here we have my reference to the Lynch case. The Cooper case said it is a law of this state that where a real estate broker or agent representing the seller knows facts materially affecting the value or the desirability of property. And by the way, when I'm talking to an attorney, I know that they're a real estate attorney by the language that they use, and it'll just spin right off of their mouth. These facts are known accessible only to him and his principal, and the broker or agent also knows that these facts are not known to or within the reach of the diligent attention and observation of the buyer. The buyer or agents under a broker or agents under duty to disclose those facts. Okay, so, and if you fail to do so, intentional tort, fraudulent concealment, or negative fraud. So folks, I want to simplify this just a little bit. If you knew about something, you should have said something about it. And by the way, we would recommend that that be in writing. Okay, so you got to make sure that that's going to be in writing. All right. And so why? Because you may need the writing to defend yourself. And so flying through here. So here's the holding. The duty of the broker representing the seller now to disclose facts includes the affirmative duty to conduct a reasonably competent, diligent inspection of the residential property listed for sale and to disclose to prospective buyers, purchasers, all facts materially affecting the value or desirability of the property that such an investigation would reveal. And by the way, doesn't that sound very similar to the language that you see in today's TDS? Okay, so I'm going to fast forward a little bit here. And this is just a repeat of what you saw before. And then down here, the agents make use of their superior knowledge. Now, you know, Wayne Bell, who was the previous commissioner, and I really liked him. He was an attorney, 20 years in charge of enforcement for the Department of Real Estate. And he said, you are held to the education that was necessary for you to get your license, stay in your lane, right? That kind of thing. Don't go outside of your field of expertise. But I don't recall anywhere where we did construction defect litigation. I remember I had it in law school, obviously, but it wasn't something that I remember teaching, because I teach the courses to get your license, and I teach the courses to upgrade and renewal licenses and things like that. So anyway, they found that the jury was well within the bound of reason when it concluded that an inspection would have included something more than a casual visual inspection and a general inquiry of the owners. And unfortunately, that left us kind of wondering, you know, well, what does that mean exactly? Okay, so the appellant's agents, that's the buyer's agents, right? Or I'm sorry, the agents of the broker were aware of the fill in the property and that erosion and settlement problems are frequently associated with such soil. So it would be akin to selling a property in Spring Valley or La Costa, where we know we have some slippery soils and things like that, and not saying anything. So uneven floor and the use of netting to repair an earlier slide, you know, stuff like that. I've walked into houses in Del Mar where literally they would fail the manometer test, right? You put a marble on the floor and it would get to the other end of the building faster than you could. So yeah, I've had that happening. So anyway, they denied, the Supreme Court denied hearing the case. And then I've got some other stuff in here for you, just so that you're aware of it. And this is why we're here today. We're here because we are held to a standard to do a reasonably competent, diligent visual inspection of the accessible areas of the property. Okay, so they don't, and then, by the way, this is in residential. So in residential 1 to 4, which, you know, in residential 1 to 4, civil code will cover the disclosure requirements of the seller to the buyer. In commercial, we don't have that. And the theory is that in commercial, the people are the buyer and the seller are more experienced and don't necessarily need the protection. So civil code protects the residential 1 to 4 buyer because we feel like they're the ones that are the most at risk of being taken advantage of. And so after you get to 5s and greater, now, you know, 5 units and larger, now we're into UCC, which I have my law book from Uniform Commercial Code. It's too far. I could go get it, but I'm not going to waste your time with it. But anyway, it's a lot simpler than the civil code. Trust me. It just, you open it up, it just says, you all be careful out there. You hear, that kind of thing. So, okay, so let's go back over, flying along here. Going to go back to my PowerPoint. That was the Easton case. And then a little side note about Lynch and versus Savage. And I put that in there for you as well. In that case, it was 1963. So it was a long time ago. So let's talk about the Field case. And so the Field case came out of our backyard. Field case came out of the Otay Mesa Water District. And I hope I have it up here. Pretty positive. There we go. There it is. So the Field case was a case, and again, I'm not going to spend as much time on this, but there was a partial publication. The case itself was a statute of limitations case, a limitation case as to how long the buyer had to bring the lawsuit against the agents. And so in the transaction, so the two-year statute of limitations established by Civil Code 2079, which is the civil code that applies to you and I, right, does not apply to claims for breach of fiduciary duty. You don't have to remember all that. You just got to remember that the buyer did not get the preliminary title report until after closing, and as a result, and see, they even quote Easton, okay? So as a result, they didn't get a chance to review the title report, which essentially said that the property could be flooded by Otay Water District at any point, and that included the residence itself. And so those were things I'm sure that if you were the buyer and you found out about that after closing, you'd probably be pretty upset about that. Plus, the extent of the easement that was on the property was greater than what the agents had gone through, making it so that the buyer felt like they were being represented properly and that they had no need to investigate further. But it turns out they were told that the property was much larger than it actually was. There was a lot of bad things that were going on there, but that PR came back. And so what's called the dicta, which is the language put forward by the judge in the case. Again, the case was a statute of limitations case. So why is that relevant to us? Well, it's relevant to us because it had to do with our activities and the judge's comment about the support of the decision. He went into a spin on the agent's actions, what the agent did and did not do in the transaction, and that's the part that's hurt us. And so that's called the dicta. And Neil Kale, and I have a tremendous amount of respect for Neil. He's one of our attorneys at CAR. Did an excellent presentation. I think it was. When was it? Was it in October? They did an excellent presentation, and he even said the dicta essentially became the law. And so, really a challenge for all of us. But here we go. Easement was more extensive, substantially more intrusive, et cetera, et cetera, et cetera. So bad news for us. It just says, the agent did not inspect the prelim in a timely manner. She didn't receive it from the title company until after escrow had closed. So again, I'll send all this to you, but 2079 again is our agency disclosure. As you know, everybody thinks of agency disclosure, and it is, but it really has to do with our obligations at law in a real estate transaction in California. Now, by the way, the Easton case, right after the Easton case, California Civil Code 1102 was enacted, which in 1102 you see the TDS. You see some of the natural hazard disclosure like defensible space. You see a bunch of stuff in there, 1102.19. You see a bunch of stuff in that. And that's the one that the seller is relying on. Okay. So again, I'm not going to take you through this whole thing or we're going to run completely out of time, but obviously we could go on for hours on this case as well. Okay. So that being said, that's the Field case. And again, did not go well for the real estate industry. Essentially, it left us wondering, what do we have to do? I mean, do we have to read the prelim? I always thought that was legal advice. I always thought that when I sit down with the buyer, and I'm going over the preliminary title report, I'm giving legal, I have to be careful about what advice I'm giving. I do a 2-hour webinar, how to read a preliminary title report. That is also up on the YouTube website. And I've had people call me on the phone and say, I've never heard of such a thing. It's amazing. But just remember, and here's how I always approach it. If this helps you, I always approach it in the form of a question. So rather than making a statement about things, I will ask questions. And so, like, for example, your buyer says to you, well, what does liquidated damages mean, right? Well, and I always like to say, I don't know, but I teach the attorneys what it means. In fact, it's about 3-hour class. But when the buyer asks me, what does liquidated damages mean? I will respond with, I can't give you legal advice, of course, but let's read it together. And so when we do that, again, I didn't come out and give them an opinion, but every single time I always say, let's take a look at it, see what it says. And when I'm done and they're done reading it, they usually tell me, oh, I get it. I understand what that says, right? Because you got to read it. Some of us who are educators, we read these things all the time, but we got to remember that our client, we're doing these every day, but the person that's buying or selling a house with us, is probably doing this anywhere from every 3 to 7 years. And so they're certainly not going to be current on the forms and things like that. So we looked at the field case. These were landmark California appellate court decisions that changed the way that California does the real estate business. And so we're going to distinguish today between the disclosures required of the seller and those required by the agent themselves. Let's talk about the two main types of disclosures. And so we're going to have statutory disclosures and then we're going to have contractual disclosures. Okay, so what's the difference? And so I always say to people, the statutory disclosure is one that's required by California law. So just remember, statutory required by law. Okay, that's all. So they also contain rescission rights. And so, with a statutory disclosure, the buyer may be able to essentially, I don't want to use the word cancel, but rescind the contract. And rescind is a very powerful word in law. Okay, and it's going to be the difference between cancellation, which comes with a contract disclosure. So statutory disclosure, rescission rights. The failure to make a statutory disclosure may give the offended party the right to reset the contract. Okay, and so reset. In other words, put the parties back in the position that they were in prior to contract. Okay, so now think about what that means. And so and I want to leave that up there because that's kind of important. So I get this, and some of you have a lot of experience in real estate, and you'll get involved in a real estate transaction, and 2 weeks later the TDS shows up, and so the buyer has a right to rescind the contract at that point based on information that may be in that TDS, not just because they got it. It has to be a material fact affecting value and desirability of the property, right? But you got to remember this, that the buyer, regardless of what right they have, they think they have a right. And so this is why, and when we look at the TDS on page 3, you'll see down at the bottom of the page, it actually discusses the buyer's right to rescind the contract. Okay, and so how do you avoid that? How do you button it up? Well, how about we tell the buyer everything about the property that we know at the time of the offer? And the law says if you tell them everything, if you give them all the statutory disclosures, then they may not rescind the contract based on those disclosures. Okay, and so that's kind of important. Now they may have other contractual rights and things like that, and things that the seller wasn't aware of course, but think about the ramifications of that. They can rescind the contract. So 2 weeks into the transaction, they see an opportunity to get out of the deal. They had second thoughts. The house they were selling didn't sell. The house, this house is not what they thought it was going to be, and so we give them the right based on getting those disclosures to decide whether they want to move forward in the transaction. So better maybe to get that to take care of that at the time of the offer rather than 2 weeks into the transaction, because invariably what they end up doing is trying to renegotiate the deal based on the fact that they can threaten or blackmail to get out of the transaction, if that makes sense. I took a listing in Lake Forest. It was a former student of mine at one of the colleges, and he had bought the property with somebody else. I had nothing to do with that. And so at the time of the listing, I went up to the property in Lake Forest. I really wasn't sure where Lake Forest was. I'm kind of a Del Mar guy. So anyway, I go up to Lake Forest and I took everything with me. I mean, I literally printed all the disclosures. So we had everything. We had the NHD, we had the TDS, we had everything. And so right there, I sat down with the seller for 3.5 hours. Now, folks, and some of you have a lot of experience doing this. If you're in the real estate business, you want to prove your professionalism to the client. early in the transaction rather than having to defend it later. Okay. And so early in the transaction, I sat down with them and 3.5 hours, and I'm apologizing to the seller. I said, I'm so sorry. This is a lot to do. I know. And he says, that's why we hired you, because we wanted to work with someone who is very thorough. And they remembered from class where I said, that if you do all the disclosures, you send all the statutory disclosures to the buyer prior to them committing to the contract, that they would have a much lesser chance of getting out of the transaction. So here we are. They had bought the property 3 months earlier. Mom passed away in the property recently. So we have a death on the property. That's going to be Civil Code 1710.2. Okay. You don't need to remember these civil codes. I just do it to be impressive. So mom dies in the property. There's unpermitted additions. They're very clearly aware of it. All of this goes down in the TDS. All of this goes down in the SPQ. We didn't use the SPQA because it wasn't in San Diego County. But although I really like the SPQA. But if you remember, the SPQ came out of San Diego. It was our old seller's additional disclosures form. And so seller fills out all this stuff. Even the avid, and frankly, I did not do the avid. Another broker in our office was there with me. He's been a broker since 71. I mean, I told him I didn't think anybody was alive in 71. And he went around and did the avid. And by the way, he signed the avid. And that's important. I want to make an important note. Do not say you did something when you didn't do it. And so the Department of Real Estate looks at that. Did you do the avid? And the answer is, well, I did not do the avid. I signed the avid. My agent did the avid, right? So under the theory of agency, that's not going to fly. Okay. Because the form actually says by the agent who performed the inspection. You're not that agent. And it's not uppercase A being the broker, right? It's not that. It's the agent that did the inspection. Okay. So be really careful about that. So anyway, back to my statutory disclosures. If you give them all of this, and that's what we did. We had a complete package. Buyer comes in, writes an offer. We go back and forth. I send over the entire package. I mean, folks, it was a lot of pages, right? But all filled in, everything. I checked every box, anything that said yes, they explained it, that kind of stuff. And so the buyer's agent said, I'd never seen anything so thorough. And I said, well, thank you for that. I assume you're complimenting my expertise on that. And they said, let me see what the buyer has to say about things. Hi, Gloria. And so let's see what the buyer has to say about things. Well, the buyer got it and said, okay, we were going to do a 30-day escrow, but you've told us everything that we need to know. Let's close it in 13 days. And the property was vacant. Obviously, mom's not living there. They're living in Oceanside. And so we sold it. We closed it in 13 days. So less than 2 weeks later, I'm buying the RV, I'm buying the boat, right? That kind of thing. I never buy those things before closing. I always buy stuff after closing. And I didn't really do that. It was just another month that I could support Linda. So my broker. So anyway, they were aware of the fact that they had everything that we knew. And that was very, very clear. And so I'm going to tell you, every time you sit down for a listing appointment with a seller, earn your money. When that very first appointment, this is your opportunity to make them proud. This is the opportunity for you to shine, right? Where you pull out all the disclosures, have them sign them all. And I had people do various things, like bring a laptop and then have them sign it on the laptop, and stuff like that. Okay, whatever. But they got to get a copy. DRE now, they used to say you have to give them a copy right away. Now they say within 24 hours. If they sign it electronically, then they'll get a copy right away. So, but that's, I've had people do that. I just printed it. And so that way I could go over it. It didn't get lost in the, the 17-inch screen. I have a larger screen, that kind of thing. So remember, my statutory disclosures may give the parties a rescission right, putting them back to the position prior to contract, which means I'm not going to have much of an argument about that earnest money deposit, am I? So it's like, I can't tell you whether or not the buyer's going to lose it. I never say buyer's going to lose their deposit. I never say seller's going to get your deposit, I never say that, right? Because I don't know what that is, right? I know that there's the guy or the gal in the black robe that'll make that decision. And if we're doing things that way, by the time we get to that, it's going to be a very expensive lesson. Okay. And so I had a lawsuit not that long ago that 3 years, right? And so they call me up at the tail end of this thing to testify on standard of care. And obviously we were successful in protecting the brokerage firm that was being litigated against. But 3 years, That's a long time, folks. That's like to, some of these people would like to get that 3 years back. Okay, so let's try to get all that done at the time of the original listing, and then if you're the agent in the transaction, try to get that stuff. If you don't get it before the transaction starts, just remember, the longer it takes you to get it, the more the possibility that people are going to use it to manipulate the transaction. All right, so huge repercussions in a real estate transaction. Statutory disclosures are easy to define. Some examples of a statutory disclosure. So anything that has Cal Civ code in front of it, right? Because that's the setup for section, right? And the next thing is like the Alt 21 on your computer that gives you that squiggly little line thing. And so that's a civil code, all right? Very big deal. So there we go. I put down California Civil Code 1102, which again is the civil code that addresses TDSs and things like that. And so there I pulled up the TDS. I don't think I've saved. I don't think I pulled up a copy of it for you. I'll discuss the TDS at length this afternoon. We're going to go in. I love the TDS. And a lot of times I end up in court and it's like, well, you answered this, but that, and so, I'm always wondering whether or not the agent explained things properly. And so the real estate transfer disclosure statement is a statutory document, and it contains rescission rights. Okay, so there's my squiggly line up there. My natural hazard disclosure law, that's actually 1103.7. So the natural hazard disclosure law became a law in 1998. I remember when it became a law, and I remember some of the hoopla about it. So essentially, based on that law, the seller has an obligation to disclose whether or not the property is located in one or more of 6 zones identified by the state of California to be hazardous zones. And so we know those to be 2 earthquake, 2 fire, 2 flood. And so there's going to be some changes to the law that I'm going to show you. I hope I didn't close it, but some changes to the law that I'm going to show you that are going to change. And I remember when I was chair of risk management last year, Gov Hutchinson said to me, because he's sitting right next to me, right? And so he said, we're introducing legislation that will require the NHD companies to do more disclosing about that defensible space stuff. And so they are. And effective the first of the year, it will become the law. And again, send me an email. I will send you that law. Okay. All right. Anything with business and professions code in front of it. So we call it B&P code. So B&P code 10177. I'm hoping you don't know what that one does, but that's one of those ones that, where they take your license for stuff. And so this is the law versus the commissioner's regulation. And I can show you both. I mean, because I pulled up the B&P code. In fact, let me show you that just really quick. It really makes a good read. So where am I here? Get rid of field. Don't want to show you that one yet. Here's my new laws. So again, I'll probably be doing a talk on this at some point. I don't know if SDR is going to have me do it, but lots of new laws in there that I think are going to be pretty cool. But I'm looking for B&P code. So here's my business and professions code. I pulled this right out of this statute, and it breaks down, 10148 and all this. I just pulled this up as an example. But remember that the regulations of the Real Estate Commission they follow the B&P code, right? They follow the law, they follow the B&P code. So these are the things that they're looking at. And here's the regulations of the commissioner, right? And general provisions and all that stuff. And so as you go through it, this is what they follow. And so they don't hide it from you. It's not like when you got your driver's license, you had to, test on what was included in the motor vehicle manual. They didn't tell you that. They never told you that you can't make a turn that starts back in the other direction over a double yellow line. That's considered a U-turn, and that's considered illegal. So people break that law all the time in Del Mar, at the post office on 15th Street, right? They come down the street and then they see a parking spot over on the left. They break the plane on the left going across the double yellow and pulling up into the spot, and then they hope nobody saw it. So, but no. Okay. So here's record retention. I just did a talk on this last week, maintaining records, reducing risk. So lots of really good stuff in here. I'd recommend that you might want to take a look at it. And again, this is my, let's see if I can figure out how to do this. Top. These are the commissioner's regulations. Okay. So I'm going to close B&P code. I'm going to close the commissioner's regulations. and I'm going to take us back over to, I'm going to leave new laws up because I want to show you something in new laws. So here we are. That's what these things do. Okay. And so there's also the Department of Real Estate issues a most frequently violated rules. And really, frankly, I think they should, right? I mean, they're not trying to sneak up on anybody. And so it's a couple of pages. I'll send that to you as well. Send me an email. Be specific about what you want. Don't just say, send me your presentation, because it's a monster package. Okay. But be specific about what you're looking for. So I'll send that to you, but it's just a sheet of, here's the B&P code, here's the commissioner's regulations. These are the things that, some of their favorite things. Okay. So failure to disclose a licensee's interest in a property, for example, is 10177, right? So interest can be any of a number of different things. It can be a financial interest. It can be I had a case where the seller, the owner of the property was in trust, and the property was listed by a broker, and the buyer calls me up halfway through the transaction and says, I just looked up the trust, and the agent that's representing the seller is the trust. And I'm going, well, okay, what do you want to do? They say, well, we'll wait until after closing and then we'll deal with it, which, is never a good thing for us, right? That means, we're going to probably go after them for failure to disclose their license status. I had another case like that back in '88. Never forget it, on Caminito Vasto in La Jolla. And the buyer and the buyer's agents were sisters. And so during the deposition, which, again, is my favorite place, but during the deposition, it came out that they were sisters. And that was the first that the seller had been made aware of the fact that they were related to each other. So remember, you must disclose a familial interest. And so in that case, they ended up losing their license over that. The seller was really angry. I was representing the seller, obviously. And so they went after that license. So East and West Coast, and I've talked about this already a little bit, have different approaches to the issue. In California, everything must be disclosed, everything material to the transaction, that is. Okay. And do you have to disclose it again and again? No, disclose it one time, do it in writing, get them to sign off on it. I'm done. Okay. All right. So everything material to the transaction. Again, if I want to find out what's material, I've got to go back to the case that happened right after the Easton case, where they defined what material was. Okay. So on the East Coast, some states prepare the disclosures for the seller. Kind of interesting. In Virginia, they have like a one-page document that the state puts together and the seller signs off on it. Why are they required? And so why are they required of the seller? And so to assure that those with the most knowledge of the property share that information with the buyer. Just like in the Easton case, where the seller was aware of slippery slopes, seller was aware of problems with the ground, seller just chose not to say anything about it. You're kind of thinking, well, if they want to investigate the property, they can. I see this a lot in offers where the flipper or the investor will be selling a place, and their defense to not doing a TDS is, I've never lived in the place. That is not in the statute. It doesn't, again, you go read the statute. It doesn't say anywhere in there, if you've never lived in the place, you don't have to make any disclosures. There are very few exemptions to that. And so, again, the decision as to whether or not a seller is exempt is a legal one. And I've had many a transaction where the real estate agent propounds forward that the seller is exempt. And I say, okay, send me the documentation on that. And so then they send me the TD, what is it called? The ESD form, right? The exempt seller disclosure form. That doesn't give me documentation that says the seller is exempt. That just says, that they think they're exempt, and so they're going to sign off on that. So remember, be very careful about that, okay? But you're in a position of knowing more about the property than anybody else is. That's who the seller is. And what about the agent? So the agent, why do we hold the agent required to do disclosures like my Avid and things like that? To assure that the real estate professional, and I put that in quotes, right? Because for those of you on this call that are also do trial work as an expert, that's 10-inch letters, on the PowerPoint up in front of the jury, because you're all of a sudden things went bad, and so now you're a professional, whereas that's not the position the seller had when you were taking the listing. So does their due diligence in the transaction? That's all. We want to make sure that you're actively involved in it. Veronica Kilpatrick, and Veronica is wonderful. She's the district manager for the Department of Real Estate here in Southern California. And she says, why do we have to do our Avid? And she says, to document the fact that you actually did it. right? And why do we have them sign it so that we can prove, we can defend the fact that we gave it to them? Same thing with the agency disclosure. Why do we have them sign it? So we can defend ourselves. And again, remember, in California, the Department of Real Estate says everything that you and I do has to be in writing, and that's because of the problems with the statute of frauds. And so an interest in land, in order to be enforceable, must be in writing. And so that's why we have to do everything in writing, and that's because the Department of Real Estate says we have to. That's just the way that it is. So some even have the potential of costing a licensee their license. And so we don't want that to happen. You work really hard to get your license. If you remember, I remember when I've got it now in several states. And so I remember that California was the one that caused me the most anxiety. I don't want to go through that again. I asked Wayne Bell, I said, when he was the commissioner, I said, hey, Wayne, I'd like to go take the broker's test again. And of course, what kind of idiot would want to do that? And he says, not a problem, Kev. He says, here's what you do. You let your license expire for 2 years. I said, I'm not doing that. I do not want to have to take it again. I just like to take it again just to see, where are we on that? And so the Department of Real Estate right now has put together a task force that includes a lot of real estate agents. And they're revamping the state exam. And so I'm kind of excited about that, because a lot of that stuff went a long time without getting touched. And so, but for those of us that are here today, we're not worried about it, right? Because we don't want to take it again. We don't have to take it again. Well, we have to take it again if we let it expire for 2 years, right? That's California law. So, okay. All right. So let's take a look at some statutory disclosures that are required by our purchase contract. And so let's queue up the statutory disclosures. I may have shown you some of this already, but I'm going to have my agency disclosure. This is the big daddy of all of them. And so you recall probably that in October of 2018, we actually went in. I'm going to pause. I got a question. Are they going to make it harder? I would assure you they are, but I don't know if it's a question of difficulty. I think it's a question of relevance. So the questions will be more. So the question on my screen, I know folks, you can't see it, but Gloria is asking a really good question, and that is the state exam going to get more difficult? And I think that for some it will, but again, remember that more than half of our licensees in the state of California, and we're static at about 437,000 licensees right now. It's not going up and down. It's kind of fluctuating by a couple hundred, every month. They've had their license less than 5 years. So people like me, we don't know how to relate to that, right? It's like I've had a license since 79, and so but I don't remember what the test was about. But that's what's happening. Times change, and they are changed again today, right? And they will be different again tomorrow. And so we want to put more current testing material on there. There's a lot of things that, remember, they can't ask about current events. They're not going to do that. I frankly don't think that the broker's exam is really that incredibly difficult in California. I think it's pretty much like the salesperson's exam. We've got 23 questions that are different. You have 50 more questions, but only 23 of them are specific to brokers. So if you don't have your broker's license, I encourage you to get your broker's license. I will help you. But yes, to answer your question, is it going to be harder? I think it's going to be more relevant. I think that's where it's going to go. So thank you, Gloria. I appreciate you asking the question. So my disclosure regarding real estate agency relationships. So in October of 2018, we changed the form. It was, we realized some time ago that rather than reacting to changes in the law, we decided at the CAR at the state level to change the law ourselves. And so the CAR attorneys and the lobbyists went in and they rewrote much of California Civil Code 2079. You see it on your screen over here, 2079. That's the part that relates to our obligations in the real estate transaction. Some of you, that was 2018. It's been 5 years, right? So some of you don't know that it used to be that the seller's agent was called the listing agent, the buyer's agent was called the selling agent, and that made no sense. For most of us, it's like, why don't we just say the seller's agent and the buyer's agent? I still talk to people today. I still slip today myself, the selling agent, the listing agent. So we changed the language because we needed to make it more plain English. In order, remember that in order to enforce an agreement, in order to force a contract, you have to have a meeting of the minds, which means that everybody has to understand what they've agreed to. And so when we were using all these crazy words for things that just didn't work, they didn't understand. And so it's going to be really hard to enforce that agreement. And so that's why, and I did not put it in the queue here, but I have the one-page purchase agreement that I was working with when I got my license. And so you can tell a lot of that stuff wasn't even here. Now, in fact, gosh, that was before Easton. Oh, wow. I didn't think about that until just now. So agency disclosure is really important. So the law says that you and I must disclose the concept of agency prior to committing conduct that constitutes agency. And that's an important thing to remember, right? So we must disclose the concept. So when I'm representing the buyer, I have the buyer sign this, before we go anywhere, right? If I'm representing the seller, I have them sign this. This is why it's at the top of your queue in the mini template that CAR has created that you use in zip forms. Okay, so remember, I must disclose the concept, but then I also must later disclose, I must confirm agency. And confirming agency happens in paragraph 2B of the purchase agreement, and that's where we confirm it. So we disclose the concept of agency early in the transaction, and then we wrap it up and confirm agency when we actually know whether or not we're going to be a single agency or into dual agency. Dual agency meaning the broker represents both of the parties in the transaction. There was a really big case that came out a couple of years ago that did not get a lot of exposure, but I was very well aware of it. But it was a case in which a large brokerage had done a real estate transaction, and the agency disclosure had not been performed until it was caught towards the very end of the transaction. Well, the commissioner's office came in and said, that's way too late. You need to disclose this concept at the beginning before you do anything. So the concept of agency prior to committing conduct that constitutes agency, and they took away a $66,000 commission. Now, I know maybe that doesn't seem like a lot of money to you, but this was 25 years ago, and it was a lot of money back then. I think it's a lot of money even today, but they took the commissions away and said, that's your penalty for not disclosing agency prior to getting under contract. Everybody good with that? I want to make sure we're clear about that. Okay, so that's my agency disclosure. So let's see. I was queuing up the statutory. Okay, so here it is: CAR form AD, disclosure regarding real estate agency relationship. I'll take you back over there. I wanted to show you something. Notice that in the statute there's no S on it, and yet in paragraph 2B, and I'm going to send them an email. I keep forgetting to do it, but they've misspelled relationship. So that some of you will actually go look that up and see what I'm talking about. And again, that's going to be Civil Code 2079. 9.13. That is our obligation at law to disclose the concept of agency and who we represent. Remember, it doesn't make you their agent. Okay, so when we're you don't become an agent until you have a written agreement with the person. So like for a seller, you have a listing agreement, and now of course with the Sitzer Burnett case, we're probably going to see. I had 83 people at my webinar the other day on the buyer representation agreement, and so I was so proud of that. I mean, it was like good. People are finally understanding that. But that agency is very, very important. And so when you have a buyer representation agreement signed with the buyer, and some of you here would definitely agree with me, then now you have a client. And until that point, I think you've been deceiving people that you were their agent when in fact you're not, until you have that written agreement. So then we have the EPA, and so the EPA comes in. It's really it's the Code of Federal Regulations is what it is. My Barry's tea became iced tea. The EPA, so in pre-1978 housing, so this is a federal rule. This is the country, okay? Technically speaking, is it a law? Well, it's an EPA regulation. Yeah, I won't get into what it really is, but okay. This is for all property built prior to 1978. And so, and that's going to be CAR form LPD, otherwise known as the federal lead-based paint disclosure. So let's just take a look at that really quick. I'll pull that up. Let me get myself out of the picture here. Here's my lead-based paint. And this is the new form. Make sure, folks, that you're using the new forms. Okay, don't be using older forms, because this form changed fairly recently, right? So you see there 1221, and a couple of changes that were made. One of the biggest ones, of course, was the lead-based paint renovation rule. And so, if you do any work on more than 6 square feet of lead-based paint in a room, or 20 square feet on the exterior of the property, then, and this has been the law since October of 2010, so you need to have it done professionally and all that kind of stuff. So please make sure you're using the current forms. And I know people say, well, how would you possibly use a different form? Well, you would be using an old form if all you do is copy transactions. When you copy transactions, you copy old forms. So in a couple of weeks, I'm just so excited. On December the 18th, I will redo all of my templates. And in fact, did I cue that up? I'm hoping I did. Let me see here. Well, it'd take me too much to get to it. Will it? Let's see. Where are we? Okay, so here we are. I'm gonna show you. This is how I do business, and hopefully you do the same thing. And part of it is not just the fact that I want to be current on everything, but part of it is also that I want to make sure that I treat everybody equally and fairly. Okay, so I'm gonna go up here to my templates. And you can see, here's my list of templates, folks. My lease template, and notice the date, November. So I just did these at the end of last month. Seller listing template, buyer offer template. Remember, when we update the forms on December the 18th, we will update the library, which is that thing over on the right-hand side that all the forms go in there. All the forms that were in there before get replaced with the new versions of them, things like that. So we will update the library, but we will also update your forms. So this is the template. We will update your templates. So these are my templates. Okay, I do, every time I teach a class, I do a template. Here's my class for the DRE I did on the RPA. Here's the BRBC class. So I have a template for pretty much everything. Okay, so here's CAR, new and revised forms. I'll do that one on Tuesday. Okay, so just remember, please use your templates in applying them to real estate transactions, because you don't know. We change things. Like, for example, on the which one is it now? The purchase agreement. So I'm going to pull up the purchase agreement really quick just to show you. I'll pull up the offer. I'm going to go to paragraph 11M, and some of you are going to laugh because I've been working on this now for quite a while. CAR had on paragraph number 11M, it was the old, this said solar systems. And so it was just something I just couldn't deal with. I sent them an email because they said they were going to change it to solar power systems, right? And so those are the little things. These are why I tell you to use your template, trust your template, because CAR will update your template for you, okay? They will not add new forms to it, but if you want to be sure that you're using the current versions of forms, make sure you're applying your template, especially when those changeovers occur. Well, this change occurred mid-year, so it's what we refer to as a soft publish. They changed it, even though it wasn't what you're used to, which is December the 16th, December the 18th, June the 26th, June the 27th, that kind of thing. They changed it mid-year. And so, I don't know, for me, it would just made me crazy because before we were selling solar systems, so we were selling, Mercury and Venus and Jupiter and Saturn, whereas now we sell the solar power systems. And that's the point behind what I was doing. And sometimes it just takes me a while to get around to telling them. So here's my lead-based paint. Again, please make sure you're using the current form, and always look up here at the top of the form, and always look down here in the lower left-hand corner. It'll also give you the revision date. When I go back and I take a look at the website, I'm going to refresh here. Here's how you find out what the forms are. Okay, so right here where it says Transaction Center, I'm going to click on that button. I'm going to go over here to Standard Forms, and again, if you need me to show you that again, let me know. But Standard Forms, and then I go down here, Forms Revisions and New Form Releases, and folks, here they are. And this is the whole list of all of our stuff that we've been doing for quite a few years. And then when I click on December 2023 quick summary, it says what I told you a minute ago. We're going to update this on, well, this one actually doesn't say on the 18th, but okay. So here's the new form. We have one new form. We have a whole bunch of revised forms. Again, remember, we'll revise your templates. We will update the forms in your templates, and then we have some business forms, and then we have some short-term rental forms that are making a comeback at this point. Okay, and I won't get into why they had taken those out for a period of time, but okay. So that being said, my lead-based paint, obviously pre-1978 housing. The argument is, at what point is it built in 78? Or we're going to do a remodel. And I know, like in Del Mar, if you leave, one wall standing, it classifies as a remodel rather than a new construction. Again, don't trust me on that. Check with them because those rules change frequently. But just be aware. By the way, the penalty is fairly significant, and it's per transaction, so it can be a bad thing. Okay, all right, and then we have the TDS, which is, of course, one of my favorites, and we'll talk at length about this one this evening. I gotta keep a track. Oh, we're doing pretty good on time. So my TDS, my transfer disclosure statement, is going to be Civil Code 1102.3. Let's go ahead. I want to pull up. Hopefully, I've got the TDS pulled up over here. Let me see. I do not see it. Isn't that crazy that I would not have put the TDS up there? While I'm on this page, here's the RE6. Now, the RE6 is published by the Department of Real Estate, and it talks about those disclosures that are required in the transfer, of a seller and or the real estate broker agent, right? So disclosures upon transfer of residential property. So again, I will send this to you. This is my reference for a lot of what I do, which is, and here they're going to call it termination right. So should delivery of any of these disclosures or an amended disclosure, right? Remember, you have a duty to amend, occur after execution of an offer or of a purchase agreement. The buyer has 3 days after delivery of the disclosure in person or 5 days after delivery by deposit in the U.S. mail to terminate the offer or the agreement by delivering a written notice of termination to the seller or seller's agent. I probably would have put the word rescission in there, but then once again, here's my Civil Code 1102.3. Very clearly, that's my transfer disclosure statement. And then they go into this great big thing. Folks, I'm going to tell you, at some point in your career, you should take a look at this. And here it is. Does this look like the form that you look at when you look at the TDS? Essentially it's the same form. They just take a picture of it and then they put it in, much like CAR did. Okay. And so there've been some changes. This is not the current version though, strangely enough. So let me pull back. I'm going to pull that back up again. I want to show you what the current edition looks like. So I'm going to go back here and I'm going to go back. Where am I going to go? I'm going to go to my templates. Okay. Remember my template? So I'm going to click that. I'm going to go to my templates and I'm going to look at my seller listing template. And I'm going to pull up my TDS. I'm just going to go over here to the search bar and I'm going to type in TDS and it's not going to give, yeah, it did. Okay. All right. So it gives me my TDS. And so open the previous workspace. So here we go. So here's my TDS. Okay. So my real estate transfer disclosure statement. So up here at the top, and again, I'm going to go deeper into this afternoon, but up here at the top, this property is a duplex, triplex, or fourplex. TDS is required for all units. This TDS is for all the units or only these units. Each one may have its own different TDS. So that was the big change to the TDS most recently. So you see this date up here, 6/23. Make sure you're using the current version of the TDS. Okay, very, very important. And remember, the law changed effective July 1st. That said that whatever the disclosures were, whatever the required disclosures were at the time of contract, those will be the disclosures you use during the transaction. So you put your transaction together and 2 weeks later, they change the TDS. You can still use the old TDS. Okay, that's all that means. All right. Okay, just make sure you're using the current version of the forms. And so while I've got the TDS up here, so again, I'm not going to go through this line by line because when I get with it this afternoon, we're going to see. I've rarely ever seen these filled out correctly. And so here, 1102.3, that's the Civil Code, provides the buyer with the right to rescind a purchase contract for at least 3 days after delivery of this disclosure. If delivery occurs after the signing of an offer to purchase, if you wish to rescind, you must act within the prescribed time period. Real estate brokers qualified to advise on real estate. Thank you for saying that, right? If you want legal advice, you need to talk to an attorney. And what's our phrase that we've coined now? We talk about the QCREA, which is the Qualified California Real Estate Attorney. As I said earlier, I can always tell whenever I'm working with, an attorney that specializes in real estate by the language that they use and the things that they say. Okay, so this is really important. You need to know the distinction. You need to know when it's time to kick it up, and you certainly need to talk to your broker if it looks like something is going to go a little crazy on this thing. You need to let your broker know right away. Let your broker make the decision on what happens next. Okay, so I always like to kick it back to the broker. All right, so that's my TDS. Again, civil code to protect the innocent buyer and seller, and remember the TDS came out after the TDS was created in 1985. I didn't show you that in here, but that was created in 1985 as a result of the Easton decision. Okay, so good. Okay, my Avid, I love the Avid. I just think the Avid just knocks it out. It really does. So it's the agent's visual inspection disclosure, and again, another form I'm going to dig deep into this afternoon, and that's civil code 2079. So let's take a look at an Avid, and so I'm going to take us out. Is it in here? Let me see if I close that little window. I shouldn't have done that. Okay, so TDS. Oh shoot, I forgot to tell you. So remember that page 1 of the TDS. Let me go take you back up there. So the TDS did change. So up here on page 1, this paragraph right here, section number 1, it's not paragraph, it's section number 1, we added no substitute disclosures for this transfer. Okay, and so if you're not sure how the seller should be completing that, because you would never complete it for the seller, then you can take a look at this. It's a quick guide by CAR, and it explains why the section was added. And so again, I'm going to go more into depth on this afternoon at 2 o'clock. But this goes through, this is really good stuff, folks. So I recommend that you use this to explain. I send this to the seller, and whenever the seller's filling out the TDS, I'm on the phone with them. I'm sharing a screen with them. I want to go over the TDS with them. It's very, very important. And by the way, that's what you need to be compliant with the Department of Real Estate. And then we have consumers guides and stuff like that. But those all go to the client before I'm going to sit down and sign things or have them sign things. Okay. All right. So that being said, my Avid, shoot, that's where we were. Let's take a look at my Avid. 12 years of college down the tubes. Okay, I'm going to pull my Avid up. And so open the workspace, and that was my TDS, but I need to go down to my Avid. And if you're not familiar with the new way of doing things, this is how you get there really quick. You click on Avid and it pulls it up over here on the left-hand side. So that being said, this is my agent's visual inspection disclosure. So arguably it is required by statute, Civil Code again, 2079. That is our statute. That's the one that holds us accountable for use by an agent when a TDS is required or when the seller is exempt. So under both circumstances, remember, you are never exempt. So the seller may be exempt from 1102, but again, remember that exemption only applies to them if all the exemption means is they don't have to use the form. They still have to disclose what they knew or should have known about the property. We had a really ugly case in Coronado decades ago. It was an EPA case. My graduate certificate is in hazardous materials management, and we had a case where the bank foreclosed on the property. I give this assignment to the attorneys in the class, but the bank foreclosed on a commercial property, and then after the foreclosure, they continued to collect rents from the tenants that were in the property, and so at one point there was TCE contamination found in the groundwater under the building that they had foreclosed on, and the court held that they were responsible. It's a long, complicated thing. I won't go into it, but they were held responsible for the cleanup of the contamination because they had exercised dominion and control over the property. If they had just resold the property with, all they owned was paper, but no, they became a landlord, and so the law said at that point that they exercised dominion and control, so they were responsible for that. So Gloria says, does the buyer and seller agent need to do one of these or just the seller's agent? The Avid is done by both buyer's agent and seller's agent independently of each other. And so your question, let me unravel the question because it's a great question. So it's like what I always tell you: you go to the property, you're the buyer's agent. first of all, the seller's agent needs to do the avid at the time of the listing, right? But the buyer's agent, they tend not to do it until the physical inspector is there. I would recommend that that's late, very late. And so we'll talk about the avid in a minute, a little bit more in depth. But for the buyer's agent, the inspector goes right, you go left. You never follow the inspector. I don't want to see your avid that says you're quoting the inspector's report. That's just going to be wrong. Okay. All right. So good question. Thank you, Gloria. So in this case, you are never exempt from Civil Code 2079. You don't have any exemptions, okay? The seller may be TDS exempt, but you still have to do this, all right? So here it is. Here's the form. I'm using our template. Page 1 is merely all about what you're going to do and what you're not going to do. Folks, if you don't use this form, don't call me. It's going to be a tough one. Down here at the bottom, invariably in almost every trial I'm in, this paragraph right here is in 10-inch letters on the board, right? And it says, essentially, it says the agent's inspection. This is the message to the buyer. Notice only the buyer's initialing this, okay? Is not intended to take the place of any other type of inspection, nor is it a substitute for full and complete disclosure by the seller. So whether the seller tells you anything or not, regardless of what the agent's inspection reveals or what disclosures are made by the seller, California law specifies the buyer has a duty to exercise reasonable care to protect himself or herself, okay? Encompasses facts which are known to or within the diligent attention and observation of the buyer. Therefore, in order to protect yourself, you need to be doing those things. You need to review any disclosures obtained from the seller, obtain advice about and inspections of the property from other appropriate professionals, and review any findings of those professionals with the persons who actually prepare them. I'm the agent. I don't do investigation, right? I do inspections, okay? So this is almost always up on the PowerPoint. And I can tell you that I've had cases where the buyer's defense was that I figured that the seller's obligation of disclosure and the agent's obligation of inspection satisfied my obligation to do an investigation of the property. Okay, that's a bad position to have, very bad position to have. And oh, by the way, I was going to tell you something else. What was it? So the buyer. So if you're the seller's agent, you don't ever want the buyer removing their investigation contingency, although I see it all the time. Or I had a transaction where the broker said the seller's only accepting non-contingent offers. Well, it turned out later on, and my buyer was a Navy SEAL, so it's like you're getting a VA loan, and guess what? You can't really write a non-contingent offer. But I had him sign all the disclosures and the contingency removal and all that. But at the end of the day, we did I called the agent. We got our deal accepted. Long story. We got our deal accepted on Tuesday. I called the agent and I said, we've got the buyer's inspection scheduled for Thursday. And the broker responded to me and said, you don't have a physical inspection contingency. And I said, well, yeah, we don't have a contingency, but we still have a right to do the investigation. And folks, this is where these lawsuits are today that I'm getting, where the buyer has waived all their investigations and then just assumed that they could not investigate the property. Well, you can waive the contingency, but you still have a right and an obligation to investigate the property. So now they're coming back with, the seller didn't tell us about this. If I'd had an investigation done on the property, I would have found out about this. Now we found out we bought a lemon or whatever. And of course, we're all, they're looking at us, right? So please take my word for it. Check with your broker. I probably wouldn't have the buyer waive their investigation. They can waive the contingency, but you still want them to do the investigation. But we got to be careful, very, very careful about how we present that. So, and by the way, in that situation, it turned out the buyer, we did do the investigation. The other agent, sent me an email. He was definitely not going to call me because it was like, because I know what he did. He called his attorney, and his attorney said, oh yeah, let him do the investigation because that's civil code. They're entitled to do one. And so sure enough, we did I got an email that says, go ahead and do it. And so we did it on Thursday. We submitted a request for repairs. The seller did $20,000 worth of work and then did the pest work as well. So apparently the seller wasn't aware of the fact that they wanted non-contingent offers, that kind of thing. So Can you explain an investigation contingency? First ever I heard about this. So the buyer has a right to investigate the property. So the seller's duty is to disclose what they knew or should have known. That's my disclosure. That's the subject of today's class, right? The buyer has a duty to investigate. That's dig, poke, go do things, right? Hire experts to look at things in the property. The agent's duty is much less. The agent's duty is just to do a reasonably competent, diligent visual inspection. So the buyer's duty is to investigate. The agent's duty is to inspect. So when I go into the property, I wander around the property and I'm looking for stuff, right? And that's very different than the buyer who really should have the property investigated. Okay, and that is dig really deep into the property and do those things that if you see signs of stuff, then you might need to actually do more investigation. Or certainly if you get a report from a professional that says that you should get more investigation, you should get more investigation, right? So that's just the way that it is. Okay, so thank you, Gloria. Good question. All right, so and then page 2, page 2 is all about the interior of the property, and I frequently see this not filled out up here at the top, and that's a mistake because you need to be able to defend the fact that you actually did it. So question is, so this is different from the property inspection. So the agent does the inspection, the buyer does the investigation. So the buyer hires a physical inspector, which should be a physical investigator, but hires someone, usually a professional with errors and omissions insurance, things like that, to investigate the property on the buyer's behalf. That's what normally happens. The agent's duty is not that deep. The agent's duty is just to inspect the property. Now, you need to be diligent about it, right? You need to be good about it. But again, your broker can advise you on how to do that. So notice here, I have a place for the date. I have a place for the time. I would recommend that you have that completed over here. Weather conditions, if you put down sunny, clear as a bell, and then of course plaintiff's counsel looks up the weather that day and finds out that it was just raining cats and dogs. We've had some weird weather, right? We have another El Nino coming, I think. And then who else was there? I want to see who else was there. All right. Okay, so again, here's the language that you're familiar with from the TDS for your obligation. Again, we'll go deeper into this afternoon. But then down here, page 3, is about the exterior of the property. And this is the box that gets people. So this disclosure is based on a reasonably competent, diligent visual inspection, reasonably and normally accessible areas of the property. I mean, it just kind of rattles right off, right? So you see this. How many times have you seen this already today? Okay, but down here, signature of associate licensee or broker who performed the inspection. Okay, so associate licensee could be a sales associate or a broker associate who performed the inspection. So don't sign it unless you did it. So in my Lake Forest example, Joe did the inspection of the property. He did his avid of the property, and his name was here, and Joe signed it. I did not sign it because I didn't do the avid. Right? So a broker within our company, all under Linda, under the housing of Linda, did that inspection, performed it on behalf of the broker, but Linda didn't sign it, Joe signed it. Everybody good with that? Very, very important. And notice I pointed out to you a minute ago that only the buyer's initialing this thing. Excuse me. Down here, I see again that the seller's not signing this. This is a change in the form that we did recently, but the seller initials it, but they're not required. Just as evidence that they've received it. That's all. Okay. All right. Okay, good. All right. So that being said, let's go back. That's my avid. I love the avid. I really do. I think, listen, if I remember, I'll never forget Pete Selecki, who was our attorney with the Rock people. And I remember him saying, you come back and you've checked the box that says, agent notes no items for disclosure. He says, I will go with you to the house and we will come up with stuff. And I'll never forget him saying, when I sell my house, now again, mind you, he's an attorney. He was a JAG. Okay. So Marine Corps, so a super guy. I love Pete. And so he said, when I sell my house, my disclosure is 6 pages long, right? He says, I disclose crickets, grasshoppers. Now he denies this to this day, but I just loved what he said. And so, I disclose crickets, grasshoppers, poltergeists. He says, they can't sue you for what you tell them. So, I'm going to put stuff in there. Okay. So, don't obviously treat it seriously. Don't disclose stuff that doesn't really exist, but whatever you got to tell them about it. So my avid is very, very important. Remember that the law says that
that the TDS is not considered complete until the seller's agent's avid is given to the buyer. Okay, so seller's agent's avid is given to the buyer. Everybody good with that? Okay, so not the buyer's agent's avid. The buyer's agent's avid is separate from that. Okay, so the FHDS, which is my fire hardening and defensible space disclosure. I don't even know. Did I even pull that one up here? Let me take a look. This was my reference to the Department of Real Estate. Showed you this already about the Q&A. Oh, here on the Avid. So this is a good Q&A. A CAR writes some really good stuff. It's the law. Agents' duty to inspect and disclose. So again, if you want these forms, send me an email and I will send you the forms. But again, please be specific about what you want me to send you. If you say send me the whole file, I just can't. It's going to include the video and all that. And the video you can get off of the website, off of the YouTube website. And so this goes through and explains it. All right. So forms TDS and the Avid. In the old days, the agents would try to fill everything they could in on page 3 of the TDS, but today you just can't do it. It's just not enough room. Let's take a look at my let's see, what was I supposed to talk about? Sorry, I jumped. We were talking about fire hardening. Okay, so again, law has changed. And so my natural hazard disclosure, and I'm sorry, I say the law has changed. The law is changing again. And so, as I said earlier, Gov said to me, he said, we're legislatively going to change the requirements by the natural hazard disclosure companies to do their job. And so this is my natural hazard disclosure. And again, this one created a lot of fanfare. And I thank the company that, I don't see who it is, but the company that provided this as an example for me. And I'm going to have to reach out to them to get a more current version. But this is essentially, these are my 6 zones identified by the state of California to be hazardous zones. And so I've got my floods. The first 2 are flood, the second 2 are fire, and the third 2 are seismic, earthquake. Okay, so it's these 2 in the middle that create all the fervor, so to speak. All right, so the fire hazard severity zones, and that's because of the fire defensible space requirement. All right, so in scrolling down through here, I see that in looking at this, yes, it is in the high fire hazard severity zone, but based on the local determination, AB 38 disclosure form is a voluntary form. Okay. All right. And then that was the only one. So that one showed up. So yes, that's going to be a big deal, right? Because why? Because, the property is going to be subject to both 1 and 2 of the FHDS. And so I'm almost not wanting to show you that, but you remember from your real estate 101 that the seller signs first. Okay, so the seller signs, because it is the seller's disclosure. All right, the seller's agent signs next. All right, and then we have the admonition as to this was prepared by a third party. This form is not even available in your library, and here's why. I'll never forget Gov saying that nobody was using it. So most everybody was ordering a natural hazard disclosure from a third party vendor. Okay, and so I don't want the seller going in there and thinking that they can complete the form. And so we just took the form out of the library. It's not even available to you in the library. So the seller signs off on it, unless the seller has knowledge other than that. But I did have a lawsuit where the natural hazard disclosure company reported that the property was not in a zone when in fact it was in a zone. And so the courts tend to award the cost of the property, right? Because you can't move the property out of a zone. I mean, that's just not going to happen. So so be really careful about that. Make sure you're suggesting good, competent companies to do these disclosures. And again, my recommendation is always to do 3, always give them 3 alternatives at least, so that I can avoid the negligent disclosure, right? And so when the buyer writes the offer, do not put in seller's choice. you have to name a company, otherwise the contract fails for vagueness. So don't put in seller's choice, name the company, have the buyer decide what company, and you've given them a list of ones for them to look at. And by the way, you want them involved in the transaction, right? Because the more involved that they are in the transaction, the less likely that they're going to litigate against you. I had a lawsuit where the buyer sued everybody except their agent, right? And why? Because they liked their agent. So, take good care of the buyer, give them choices, do things. Okay. So here the company represents, they've got insurance for this. This is a good thing. And then down here, the buyer signs it. There's no place for the buyer's agent to sign it because the statute doesn't require it. All the statute requires is that the buyer's agent deliver the report to the buyer. Okay, that's all they require. And then we go down deeper, and we got all this other stuff down here. And so my fire hardening defensible space, I don't even think I have it. It's in here in the new version of this, and it's going to take me too long to find it. But CAR has created a really good. Let me go back to the PowerPoint. Has created a really good form that's going to change now as well. But the FHDS has on it an explanation up at the top that if the property qualifies for this, then you do paragraph number 1. Paragraph number 2, if it qualifies for that, then you do paragraph number 2 down at the bottom. And so they do a pretty good job. And then they have a defensible space selection tree at the very bottom, which I wish they would, make them interactive components, but they're probably not going to do that. But now again, we went ahead and we changed the law rather than, having to defend these things. We just went ahead and changed the law. So the final inspection report, including defensible space compliance. And again, that law is going to change here pretty soon. The laws, by the way, usually change on January 1 and July 1. That's why our forms change at the end of December and the end of June in anticipation of the laws that are about to take effect. So we already know what laws, when I showed you that new laws thing, we already know what new laws are going to start in January. That's why the attorneys and the Standard Forms Advisory Committee have been working on these forms to get them ready for that change. Okay. All right. So home fire hardening, that's Civil Code 1102.6. You don't need to remember these civil codes. I just, I looked all of these up, read through all of the stuff on them. CAR form CMD, that's my carbon monoxide detector disclosure. That's also going to be in Civil Code 1102.6. I don't even think I pulled that form up. Let me take a look at what else I pulled up over here. I'm going to close out my NHD. There's my new laws. Lead-based paint we already talked about. Agents visual we already talked about. New laws. I wanted to show you that there is a new law. And now, of course, we have the problem with the ADUs, and guess what? It's all about tax revenue. I love it. Okay, so I'm scrolling down through here pretty quickly. Oh gosh darn, where did it go? Lots of housing issues. Reusable tenant screening reports. Landlord termination. I got to send this to a couple of companies that I work with that are doing property management, lead renovation. So this explains even further that rule that we saw a minute ago that takes effect January 1. Partition, you're probably not going to experience that unless you're doing court ordered sales. Gosh darn it, you're going to bet it's going to be at the very end, or I've already passed it, which is worse. You all know already that you have a new requirement for implicit bias training. Postponed until next year. And landlord tenant, they're just telling you they're working on a form. Okay, so I can't find the part I was Oh, here we go. At the very end. So disclosures. And so I said to this earlier, disclosures required by the TDS law in effect on the date the parties entered into the contract shall be the disclosure requirements that apply to that contract. Okay. And that's what I said before. So if you go under contract on May 1 and you get the TDS is out and it's been acknowledged by everybody, then they change the TDS on July 1, you don't have to use the new one, you can use the old one. Okay, and that's kind of essentially what that says. Okay, all right, let's go back really quick here to the PowerPoint. So my CMD is my carbon monoxide disclosure. By the way, and I don't have it in here, but it is that information is also included on the bottom of page 2 of your TDS. Smoke detector statement of compliance, California Health and Safety Code, also included on the page 2 of the TDS. Water heater bracing statement, also included on page 2 of the TDS. There's a lot of stuff on page 2 of the TDS that we added by statute to the TDS. You don't need these separate forms. Invariably, I always have somebody, somebody's transaction coordinator sending me a bunch of forms that aren't necessary. And I always point out to them, here's where it is. And they don't want to hear it. They don't want to learn. I mean, whatever, I get it, but okay. But water conserving fixtures compliance, that's my WCMD, right? So that's Civil Code 1101. No CAR form NHD, and I said that to you earlier, the natural hazard disclosure, there isn't a form. We got rid of the form, and that's Civil Code 1103.7 if you're keeping score. No form on seismic hazard. It's included by most of the natural hazard disclosure companies. Make sure these are statutory requirements. So I looked up every one of these, and I'm going to tell you that I have reviewed natural hazard disclosure companies that do not provide all of these forms, and these are required by statute. Okay, so seismic hazard, special flood hazard, state responsibility area, fire hazard. We have no CAR forms for any of these. Okay, so very high fire hazard severity. That's I've given you all the Civil Code 1103.7 again, all the codes. No CAR form for airport in the vicinity. That's a statutory requirement. That's 1103.4, area of potential flooding. And again, that's California Government Code. And then, okay, there is a CAR form for tenants. So if you're doing landlord tenant stuff, then be aware that there is a tenant flood hazard disclosure form. You know what? I can show you that one. Let's go back to this program, and that's going to be my TFHD form. So let's go to my leases. Whoops, didn't want to go there, but all right, we're there. So can you see this? Okay, so my lease template right here, I'm going to open up my lease template, and then I'm going to do a search, and I'm going to look up my TFH. Oops. Where is it? Oh, that's crazy. Where did it go? Well, actually, I took it out, and here's why. Because it is in the lease agreement. So when I pull up the lease agreement, the residential month-to-month, the LMM form, I'm going to pull up that lease agreement, and then I don't have it over here on the right-hand side because it's included in the document. So again, CAR, creating mini templates for us, which is I think wonderful that they're doing that, but here's my tenant flood hazard disclosure. And so I'm going to talk to them about this, but their default language says it's not in a special flood hazard zone. Okay, and so I'm gonna see if I can get them to change that, because so we've checked the box that it is in the zone. And again, the immortal words of Pete Selecki, if you tell them in the zone, it's in the zone, and it's not in the zone, probably not going to have a lawsuit over it. But if you tell them it's not in the zone and it is in the zone, you're probably going to go to court over that. So here I've checked the box in our template that says it's in the zone. Okay, now it's easy enough for you to tell, especially if you're doing leases. Right down here, http myhazards.caloes.ca.gov. When you go there, you can go to the San Diego website from there that will tell you, and we always include this in all of our disclosures with a tenant when we're renting to a tenant, when we're doing leases. And again, because it's required by law, you have to make the disclosure. Okay, so we make the disclosure to the tenant. We also and notice this is 6 of 23, so this just changed. So we're going to have the tenant sign off on this, but we're also going to go to the San Diego website again through what I just showed you, and we're going to pull up that whether the property is in. You type in the address, and then you can see if the property's in the zone or not. We're gonna print that. We're gonna have the tenant sign it. That whether it's in the zone or not in the zone, we're going to be able to say that we told them so. Okay, that's all. Pretty easy stuff. Okay. I'm racing here, but we're doing pretty good. So no earthquake fault zone. These again are all included in your natural hazard disclosures. Notice or actual knowledge of release of an illegal controlled substance. That's my MCN. And then again, California Health and Safety Code. And by the way, even if the seller is exempt, they have to still disclose whether they were aware. And that may be my exempt seller disclosure form. Flood disaster insurance requirements required by U.S. code. Gas and hazardous liquid transmission pipeline notices are 2079 again. But remember, they're included in your SBSA, your statewide buyer and seller advisory. So make sure you're using that form in your real estate transaction. Death on the property in the last 3 years. Again, that's 1710.2. You must disclose the death, and then if asked, the manner of death, unless they died of AIDS or HIV related, and then you don't have to tell them. So I don't have to tell you usually means it was AIDS or HIV. Okay, so anyway, death on the property, absolutely required by law in California, only for 3 years. Then you have situations like Heaven's Gate, the Sharon Tate murders, the Manson murders, whichever you want to call it. Those I think are going to go more than 3 years. And here's why. And again, I'm not giving you legal advice, but those are heinous acts, right? So Heaven's Gate, 40 people off themselves on this property in Rancho Santa Fe. So do you need to disclose that? Of course, as the seller's agent, I'm like, oh my God, do I have to disclose that? I don't know. They can't sue you for what you tell them, right? Remember what Pete said? So I think you should. The guy that bought the place, after the death, bought it, because he wanted to make a movie out of it. He did. He made more money on he paid $750,000 for the property when it was being marketed at $2.2 million. And so, he bought it for a killing, made a movie. I'm sure he made a killing on that too. And no pun intended here. And then I don't know, maybe sold it since that time. I imagine he probably has after he got out of it what he could get out of it. Okay. So just remember, death on the property is required by law. And so the seller must make that disclosure. Notice that disclosure is not included in the TDS, which is kind of interesting. If you think about it, hi, Wesley, welcome back. It's not included in your TDS, but it is a statutory disclosure. So if you know that if the seller is aware of someone has died in the property, then they either the ESD, if the seller is TDS exempt, right? Or make sure you're using that SPQ, because the first paragraph in the SPQ is going to talk about those statutory requirements that the TDS doesn't cover. And again, deep into that this afternoon at 2 o'clock. So Megan's Law disclosure, Civil Code 2079. Megan's Law disclosure is in your purchase agreement. It is in your lease agreements. So you don't need a separate form for it. Although the form does show up in your library, but you may not, you don't necessarily have to use it because you've already made the disclosure in your contract. Notice the special tax and or assessments. So like Melrose, for example, a bunch of civil codes on that, government codes, all kinds of stuff in there. I often tell people, they check the box that says no assessments, and it's like, really? Let me pull up the tax record for you, and I'll show you most every property I've ever seen. I don't know if I've ever seen a property that did not have an assessment on it. So, I just take it for granted that in that listing in the MLS that they didn't look up the tax record. So, all right. If the seller has actual knowledge of industrial use and military ordnance, and I just sent them an email because on the lease agreement form, they spelled ordnance IN. So IN would be a rule or a regulation, but ordnance is stuff that goes boom. Okay. So if the seller has actual knowledge of it, then they must make that disclosure. And that's Civil Code 1102.17. Also Code of Civil Procedures, 731A, also 1102.15. It's just everywhere. If you're aware of stuff that goes boom, you got to tell people. Okay. All right. Contractual disclosures, just as we get into this. So one that is required by contract. So not necessarily one that is required by statute. Remember, statutory disclosures contain rescission rights. Contractual disclosures are going to contain cancellation rights. And so here we go, cancellation rights. Is everybody okay with that? Very, very important. So some of my forms are going to be like my well, let me finish the thought here. So cancellation rights may be, and I put that in big bold print, may be an opportunity for the parties to exit the contract without penalty. Maybe. So I'm more likely to be able to fight about a contractual disclosure than I am about a statutory disclosure. If you didn't make the statutory disclosure, then you probably didn't do your job as the seller's agent. Okay. But a contractual cancellation right is different than a rescission right. So, you know, the buyer does a physical inspection of the property, and they come up with, you know, the report says it's got $10,000 worth of work. I'd probably argue that's material, although the buyer knows they're not buying, you know, squeaky clean, brand new. That even brand new homes, I had a 16-page inspector's report on a property that was not even finished yet. So, folks, you should be doing those, having the buyer do those physical inspections on new home constructions as well. Okay, so, but anyway, maybe an opportunity for the parties to exit without penalty. That's going to be an issue for the trier of fact. So the judge, okay, that kind of thing. All right. So my CAR form SPQ, which is my seller property questionnaire. Again, I'm going to get deep into this afternoon. We will cover that. Seller property questionnaire, again, came out of San Diego. It was the seller's additional disclosures form. CAR saw it. They go, wow, that's a pretty good idea. We should probably be thinking about that as a statewide form. And frankly, I thought they did a really good job of it. But the SPQ works. You know, you have your TDS, which is statutory. You have your SPQ, which is contractual. And then we have, you know, so San Diego created the SPQA, which is the seller property questionnaire addendum, which again is contractual, and only if you put it in the contract. So the FERPTA form, as we know, is the seller's affidavit of non-foreign status. You know, is it required? Well, the answer is this: if you don't have the information that it's asking for, and again, we have the FERPTA, and then we have the QS. If you don't have that information, then you, as well as the buyer, are in the food chain of people that are going to have to withhold from the seller's proceeds a portion of the sale. So in California, it's 3 1/3% of the sales price, or 9 1/3% of the profit on the sale. And then there's the federal version of it. And so you need to make sure you have those forms. Those are, I'm going to tell you that it just would be stupid not to have it. Okay, I hate to use that word, but you need to have those forms in your transaction. Escrow will provide you with should provide you with a qualified substitute. We had a lot of pushback on that when we first came out with that. But our FERPTA, there's a place for the seller to put their social security number. But again, I don't want that in my file. And so, you know, at least in Linda's office, the agents are required not to do to do the FERPTA, but check the box that says you can get the rest of that from the escrow company. Okay. All right. SPQA, I mentioned it a minute ago. I probably should have put that up right after the SPQ. The SPQA is an awesome form. And I've had people who have, who have said, I don't need it because I've got the SPQ. That is not true. So, you get TDS, clearly you're not going to argue about that, right? Then you have your SPQ, and your SPQ is a contractual form. Your SPQA, so the SPQ kind of unpeels the onion from the TDS, okay? So it asks the seller questions about things that are intended to jog the memory of the seller in the disclosure requirement. The SPQA is a specific form specific to San Diego County. So it is intended to unravel what the SPQ didn't cover. So again, if you remember that the SPQ came from the SAD in San Diego, we created the SPQA to touch on this stuff. So in this afternoon's class, I will show you there's a lot of it that, the SPQA says, we don't need that. You covered it just fine in the SPQ, right? So it's not a duplicate of the SPQ form. I had an attorney call me on the phone and said, I'm defending a brokerage. and he says they did not do the SPQA in San Diego County and did not do the SPQA. And before I had a chance to say anything, the attorney says, I know it's the standard of care, standard of practice in San Diego County. And I said, yeah, counselor, it is. It's just going to be standard of care, standard of practice. And so he said, okay, all right, I'll get back to you. Never heard from him again. So obviously they settled the case. But yeah, you need to be using that SPQA. So you got TDS, SPQ, and then the SPQA. Okay, so make sure the three of them should be placed side by side next to each other. If you do that, you'll have it in your head. The graphic will be that you can see how they flow from one to the other. So that's my advice, my non-legal advice. Check with your broker. Okay, all right. I had somebody just recently who said their brokerage doesn't require the SPQA. And I was really fascinated by that comment because their broker of record was the chair of the committee at San Diego. So I kind of doubt that, but okay, I get it. All right. So anyway, I'm just going to keep asking for it. If you ever have a situation where they refuse to provide something, just document the fact that you're asking for it. So the first email says, send us this. They say, we're not required to send you that. Okay. Second email I'm going to send them out says, we need this. So they say, hey, stupid, I told you, we're not going to give you that. We don't need to. And then the third time, I'm going to have the buyer sign the SPQA blank. Now, I'm not going to fill it out, but it'll be blank. And I'm going to have an email with the buyer that says, this is what I've been trying to get them to provide to you. And they're refusing to do that. Every one of my transactions has that in it. I'm always going to make 3 attempts. Okay. So if they're refusing to give you a disclosure, then you need to document, especially standard of practice, the standard of care in San Diego, then I'm going to have that in writing that they refuse to do that. Okay. All right. That's called risk management. All right. And I want to make sure I practice risk management rather than damage control. Damage control is where I have to hire a whole bunch of lawyers to defend us for some of the things that we do versus risk management. I'll take care of it before it becomes a problem. I know I'm preaching to the choir. Some of you on this call today know exactly what I'm talking about. So the above are the hottest items in your disclosure list, and we have some warnings. So your cyber crimes advisory is always included. It's in my template. Wire fraud advisory, local area disclosures, clearly, statewide buyer and seller advisory, market conditions advisory. We're not going to have a file that doesn't have that in it. Okay. Water conserving plumbing fixtures, environmental hazards disclosures. On the note of the natural hazard disclosure companies, not all of them provide the environmental hazard disclosure. And the environmental hazard disclosures are required by law in sales and leases. And so because we normally, again, make sure that the company that you're suggesting has that, all right, that provides that. But when you're doing a lease transaction, chances are pretty good you're not getting an environmental hazard, or you're not getting a natural hazard disclosure company to provide that. So it is available in your ZipForms product. In fact, I think I'm in that window right now. Let me just pull that up really quick. So this is in my lease template. We're flying back and forth on this one enough. So see right here where it says environmental, this is in my lease template. So I'm going to click on environmental and there's my 6. Okay. 1, 2, 3, 4, 5, 6. So again, I must by law provide that to the tenant. And so there you go. I've got it. This is going to be included in all my leases. Okay. All right. Good. And then let's see, honorable mention. I'm going to put that in there. So new laws. And I told you already that I'm more than happy to send you the breakdown on the new laws that are going to take effect the 1st of this year. And then I have new forms. And again, all of this is in my newsletter. So if you're getting my newsletter, you have clickable links that take you straight to it. Okay. All right. So I had somebody call me today, or not call me, send me an email today. Somebody who comes to all my webinars, and she says, I couldn't make it to the buyer representation broker compensation webinar that you did on Tuesday of last week. And so I sent her the link. I will send you this stuff, folks. I don't want you, I'm not charging for any of this. Okay. So this is something you get. Okay. When I start doing my podcast, we're going to probably make it like $5 a month or something, just so that I can block it so that plaintiff's counsel won't spend the $5 to get into it. But thank you for joining us. I'm going to get you done here a couple minutes early. So all about disclosures. If you want to view any of our previous disclosures, get your QR code reader ready. All have telephones. I'm sure they have QR code readers on them. And so here it is. Go ahead and click on that, take a picture of it. That'll take you to the YouTube website. I had to learn how to do all this because it wasn't getting done. But the DRE has required me, because my RPA and my BRBC have been approved by the Department of Real Estate for continuing education. So 5 hours on the RPA, 3 hours on the BRBC. So they've made me create a place on the website where people can go to see the general information page. And so anyways, so I'm waiting to see if San Diego's interested in having me teach any of those classes, but we'll see. Can you send me the link to the last webinar? If you're looking for the webinar, I'm going to show you right now. You can go pull it up yourself. You're talking about the video, right? So so here you go to at Burke Real Estate Consultants Inc. That will take you right to all the webinars. And then I had to learn how to do it. I had to learn how to create QR codes, learn how to create bit.ly links. Here's the bit.ly link that'll get you there. So because I want you to have access to this. This is my goal. All right. Please remember to like and subscribe. So on YouTube, I'm going to start doing a lot of stuff on YouTube. On YouTube, if you like, it makes me feel good. If you subscribe, and I have a lot of subscribers, I don't make any money off of it, but it does let you know ahead of time when you go into YouTube that, hey, Kevin has loaded another video. So today, this morning's class, and then this afternoon's class, I will load up this evening into the YouTube website. So you will have those again as well. And so Gloria, if you want copies of that BRBC, which was on Tuesday, it's up there already. I just thought we just knocked it out of the park on that. So make sure you subscribe so that you can get access. It'll let you know when there's new stuff. You have anything you'd like me to speak about, education@sdar.com. You can send them an email, copy me, send me an email, copy them, whatever. SDR wants to make sure you're taken care of. And then my weekly email updates. I don't put anybody on that unless you ask to be put on it. So if you want to get onto the newsletter, and the newsletter is going to contain, thank you, Gloria. The newsletter is going to contain all the links, right? So everything that I'm talking about talks about my notice of default purchase agreement, the issues with that, and the state and California's position, the Department of Real Estate's position. So a lot of this stuff, I make it really accessible to you, but I don't put your email address on it and don't send it to you unless you've asked for it. Nobody ever unsubscribes. I probably have had, since I've been doing it for many, many, many years now, I probably had 5 people unsubscribe, which kind of surprised me, but I think most of those got out of real estate and just decided it wasn't for them. I think this is a great career. Hopefully you're having as much fun as I am. And hopefully you're doing well. And so anybody else have any questions about anything that we've talked about? My tea is a goner. So absent that, I want to thank you all for being here today. And again, this afternoon I will be back, and I will be doing the what am I doing? TDS, SPQ, SPQA, and the Avid, and we are going to kill it. I'm going to drill deep into those forms. So hopefully I get to see you there again. If you can't make the live version, where you can ask questions and stuff like that, then I do look forward to seeing you. Thank you, Betty. That's very kind of you. Thank you. And so I'm always trying to give value. Okay. So thank you. That's very kind of you to say that. So I want to thank you all for being here today. And as I say, from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Thank you for being here today. Bye-bye.